Hi, welcome to the legal wing of Perchance to Read, where I read one word or legal term and quickly break it down for trial watchers. As I say each time, there's no focus on any one trial in this series, just the trial words. And as always, nothing in this video is intended to be legal advice to anyone about anything. Okay, let's jump right in. The word limine, pronounced limine or limine, and as you'll see I lean limine, is Latin for at the threshold. I reviewed motions in great detail in a separate video, but to recap in one sentence before we move on to motions in limine, a motion is a grand yes or no question to the court, a request that the court or parties do or not do something in a case. Thus, a motion in limine is a motion filed at the threshold of the trial, or before the trial begins, so a pretrial motion, requesting that something happen or not happen. Specifically, motions in limine are filed by any party who wants the court to exclude evidence the other side wants to admit at trial. So when one side plans to introduce certain evidence, say the smoking gun, or to call an expert witness to testify, and the other side doesn't want that evidence or testimony introduced or adduced at trial because it's unduly prejudicial to their own side, they would file a motion in limine asking the court to exclude that evidence. Here's the thing, all evidence is prejudicial in some way. There's no point in introducing or adducing evidence if it's not going to help that party's case and work against the other side's case. It's going to be prejudicial to the other side. In fact, if it isn't, it arguably is not relevant because it doesn't prove anything. However, if evidence does tell part of the story, but it is unduly prejudicial, meaning it does more harm to a party than it does to advance getting at the truth, a court will be disinclined to allow it to be presented at trial. The party the evidence hurts will file a motion in limine seeking exactly that result, seeking the court excluding the evidence at trial. Motions in limine are high-stakes motions because a case can be won or lost on whether a certain piece of evidence or some testimony comes in at trial. For example, if a defendant on trial for forgery, generally a non-violent pen-to-paper crime, has a record of being convicted for assault and battery, and the prosecutor tries to introduce that record as evidence of the defendant's quote-unquote criminal ways, the defendant will file a motion in limine seeking to exclude that evidence because the history of violence could unduly prejudice the jury against the defendant. The assault and battery convictions are not relevant to the forgery charge and may only serve to make the jury dislike the defendant unfairly and view them as dangerous and difficult and therefore likely to commit the dishonest forgery. Nor is the fact that the defendant doesn't get along with their neighbor relevant. Who cares about the defendant's garbage can or dustbin dispute with their neighbor in a forgery trial? If the jury hears irrelevant, unreliable, or sensational evidence designed to distract, inflame, or confuse the case, it may irreparably put at risk the defendant's ability to get a fair trial and violate the defendant's constitutional right to due process. The court will carefully weigh all factors of a fair trial and due process when deciding whether to allow in evidence. By the way, if the forger forged a check in his neighbor's name over that garbage can dispute and then got into a fist fight with the neighbor and was arrested for assault and battery, the evidence we said a minute ago was unduly prejudicial, the assault, battery, and garbage can dispute, because it wasn't relevant, might now be relevant in the forgery trial. The theme would be something like, the defendant beat up their neighbor when the neighbor found out the defendant forged a check in the neighbor's name made payable to the waste management company for the garbage cans. Suddenly, we may want to know about the assault and battery and dustbin or garbage can dispute. It depends on the facts of the case and circumstances surrounding the criminal behavior alleged at the current trial. These are the kinds of questions the court will weigh when a party files a motion in limine. Motions in limine are filed in courts all over the United States all week long, every week, because in just about every trial there's going to be some evidence one side wants to admit that the other side will want to exclude. Because they're pretrial motions and because of their nature and what their outcomes can mean to a case, motions in limine are never argued while the jury is in the courtroom. The obvious reason they're argued before we have a jury is to avoid the jury hearing something that is later excluded that they won't be able to unhear and leave out of their deliberations. The other reason they're argued before the jury is impaneled is so that parties know what the parameters of the case will be as they select the jury. If I know the court is going to allow the assault and battery evidence into the forgery case, I'll want to ask prospective jurors if they have any history, whether as a defendant or as a victim of assault. If an evidentiary issue comes up at trial, because not every evidentiary issue is always resolved pre-trial, the court may address it in a quiet sidebar that the jury can't hear, or during a time when the jury is not in the courtroom. So, if you're trial watching, you may see that parties argue motions during a morning session before the jury is called in and the television cameras roll. Or you may hear the court ask parties to stick around after court recesses for that day and the cameras are off. In those times away from the jury and the cameras, the court could be addressing with parties a multitude of issues, including witness logistics and schedules, but it could also be addressing motions in limine that have come up mid-trial. Maybe a witness has been added and parties want to frame the scope of their testimony outside the presence of the jury before they take the stand. Maybe some new piece of evidence that previously was thought to be unavailable suddenly now is available, and it can be argued in a motion in limine as to whether it should actually be admitted. Just because it's available now doesn't mean it automatically comes in. So many things can happen. As you know, trials are dynamic. The need for a motion in limine could come up once the trial has already started. And there you have it, motions in limine, or motions in limine. If this was helpful, please hit that like button. Links to my other trial watchwords are above and in the description. And it bears repeating, nothing in this video is intended to be legal advice for anyone about anything. Thanks for watching.